Today's ruling changes what college athletes can receive, but it was only, again, a modest, narrow ruling because the only issue here was whether the NCAA could continue to put restrictions on what are called benefits related to education. And that included science equipment, musical instruments, computers, post-eligibility scholarships and internships, and other benefits like that. Also some cash awards for academic achievement. And the Supreme Court said, you're not allowed to limit that at all. And they affirmed the lower court because it said, that's not going to destroy the difference between college and pro sports. Really what the definition, at least as the NCAA has put it forward, of amateurism is that they are not paid beyond their educational expenses. And all that they were asking for in this case is to be paid more of those educational expenses, not to have any limit on it. And the court said, you're right, there is no reason to limit those benefits you're getting as long as they are related to education. They did not touch all the other payments. They didn't address whether the NCAA could continue to limit payment for compensation, payment for performance, payment for name, image, and likeness. But in a concurring opinion, Justice Kavanaugh said that it seems very likely, it's just one opinion, but it seems very likely that all of these restrictions that the NCAA have in place violate antitrust law. And there is no reason they should be able to continue to do it. That the amateurism defense they put forward does not justify preventing college athletes from receiving additional compensation, even if it's unrelated to education. Now, that's just a single concurring opinion. It does not have the force of law, but it is a pretty good indication of where the court might be headed when one of the most conservative justices on the Supreme Court is very clearly stating that he believes that labor, in this case college athletes, are being exploited at the hands of management, which in this case would be the NCAA. I would imagine it's only a matter of time before another lawsuit is filed that asks for the whole system to be blown up and argues that any restriction on athlete compensation is illegal. In those cases, frankly, plaintiffs' lawyers may be drafting those complaints as we speak. It doesn't surprise me based on the questioning during oral argument and based on, I think, the shifting views of a lot of people that the current system of college athletics is unfair and unnecessarily restrictive to college athletes, that even though there are billions of dollars of revenue being generated, very little of it goes to college athletes. And I think, as a lot of the justices noted, too much of it seems to be going to the coaches and to facilities, that there's an equity there. So I'm not surprised that the Supreme Court decided to give the NCAA less deference under the law.